All right, let's proceed. Good morning.
Good morning. May it please the court, my name is David Lewis, and I represent Ricky McGee. This case breaks down into three basic categories: threat, a gun, and a reward. I'm going to start talking today about the threat. A man named Randy Farrell, well, let me back up. When the defendant was arrested, a photograph was found in his room and seized by the police. It appears at pages 29 and 30 of the record. The man in the photo is a man named Erie Fenderson. He's holding two guns, one silver, one darker. Randy Farrell was going to testify for the defendant that the silver semi-automatic was his, that he was in the room at the time, the silver gun was his, and that the revolver was Fenderson's.
Assuming he was planning on giving that testimony, that was prior to his consultation with a lawyer, wasn't it?
Yes.
So he consulted with a lawyer and then decided not to testify, correct?
That leaves a few things out, but yes, that's not incorrect.
So what's wrong with that decision? He consulted with counsel, and then after consulting with counsel decided not to testify for concerns about perhaps implicating himself in some kind of crime.
If there were no additional facts, this is why it's a problem in this case. Because if that were all that were in the record, if those were the only facts, we wouldn't be talking about it because I wouldn't have raised it because it wouldn't be an issue. The reason it's an issue is because Sergeant Detective Keeler walks up to him, knows him from a previous case that's not resolved, says, "What are you doing here?" Farrell explains to him what he's going to do, and Keeler says, "Come with me." And they go into a private room, just the two of them. Now, what happens in the room? Well, we know what happens when they come out of the room. Farrell goes and talks to my client's lawyer, Attorney Kamholtz, and says, "I feel threatened, I feel intimidated. I think I need to talk to somebody." So,
I think I need to talk to a lawyer.
well, the thing, it's in Kamholtz's, the contemporaneous, Attorney Kamholtz filed an affidavit with the new trial motion, the first new trial motion that was filed a couple of weeks after the conviction. So it's essentially contemporaneous. And Attorney Kamholtz explains in detail exactly what events occurred. That Farrell came up to him, what he said had happened, and what he felt like. And that he had been threatened and intimidated by Keeler. And the statement, I think, is in the record from the March 2003 hearing when Farrell testified, was that, he's a cop. Of course he can do things I don't know about. Farrell was concerned about the other case. Farrell was a witness to a shooting that was a Commonwealth witness. He had testified at the grand jury for the Commonwealth. And it seems to me, if all Keeler wants to tell him is, hey, you got some fishes to fry, you better watch out, you should probably talk to a lawyer, why the private room? Why can't he just tell him that in the hall? He takes him into a private room and he threatens him. And I think that, the trial court found that she accepted Farrell's testimony or Farrell's version of the events, and the Commonwealth has stated that that's the version that the Commonwealth or the trial court accepted. And frankly, I defy anyone to read that testimony and reach that conclusion. And I point this out in the reply. The benign version of that, hey, you really should get a lawyer, is Keeler's version. That's not Farrell's. Farrell's version is they're talking about perjury, he's intimidating him, he's threatening him. Farrell thinks something's going to happen to him in a murder case that he's a Commonwealth witness in. That's not resolved. They hadn't charged anybody at the time. And Keeler's reputation preceded him, which is why I filed the motions to get more information in that regard. Because in 2003, the trial court reached a result that she reached. My understanding of the record and what's going on is that after that, that's when Sergeant Detective Keeler's reputation and conduct really came more to light. And that's why in the record, I think it's about page 203, there's an excerpt from the Clemente case. And it was about 18 months prior to my client's trial. And there's a sidebar where the defense counsel goes to the judge and says, Keeler's outside scaring the hell out of our witnesses. And I'm paraphrasing. He says some other stuff that basically says, tell him to stop it and get away from our witnesses. So it is another case. It's not this one, but it's the same basic time period and it's the same basic conduct. My client, Randy Farrell's testimony was not cumulative of anybody's, which is it's an argument that the Commonwealth makes. It's not cumulative of Emerson Ocampo.
So are you saying, I'm sorry.
So let's say we agree with you. What's the remedy?
Remedy's reversal.
And
He was-
then,
that- well-
then it goes back for another trial.
Correct.
And then this same witness may or may not testify. And assuming he continues to invoke his Fifth Amendment privileges, you're in the same position, aren't you?
No, he testified in March 2003 to what happened with Keeler, as well as he would have testified
As
at
to the
trial.
ownership of the...
Yes, yes. Which is a separate issue that the trial court never considered. There are really two parts to Farrell's testimony in March 2003. There's the part where he talks about being in the private room and threatened by Keeler, and there's the part where, hey, this is how I would have testified if Keeler hadn't threatened me. And in that part, he says, the silver gun was mine, the revolver, as far as I knew, was Fenderson's. When I got there, he took it out of his band, he took the picture, he put it back in his band. I'd seen Fenderson with guns at least 10 times previously. I'd never seen the defendant with one. I'd never seen the defendant even touch one.
Can I ask you, are you basically saying that he would not have testified even had he not spoken with the lawyer?
He
That
absolutely...
after having been, as he says, intimidated by this police officer, that alone was the reason he didn't testify? Is there anything, I mean, when he testified, you said in March 2003 that he had been intimidated and didn't give the testimony that he was going to give. Is he saying in his testimony that, it was the intimidation that kept him from giving the testimony, even without having received legal advice? He knew he wasn't going to testify just as a result of having been intimidated?
He expressed, my recollection is he never said it quite that succinctly. That may be wrong. My recollection is when he went to the defense counsel and said, this is what happened, I'm threatened, I think something's going to happen in this other case. Before talking to Keeler, prepared to testify. That the silver gun is his. After Keeler, no.
But a judge might have also said maybe you need to talk with a lawyer first.
Which is exactly, that's what should have happened. What should have happened is Keeler should have said, what are you doing here? He tells him, he says, don't move. Should have gone to the courtroom and said, I think someone at least needs to talk to this guy, and so he can make up his decision. Mm-hmm. A government agent shouldn't be taking defense witnesses into a private room to have discussions with them, where they then come out and say, I feel threatened and intimidated, and I think something's going to happen to me. My recollection of the tenor of Farrell's statements was that he didn't think it was that big a deal. He's like, he understood what he was saying.
Did he have liability for having that gun? Potential liability for having that gun? Did he have a permission to have? Were there criminal charges that could have been lodged against him for having that gun?
There were never any charges against him.
No, but could have been lodged against him for having that gun. Did he have exposure by virtue of having that gun?
Admitting ownership of it?
Yes.
Probably, yes.
Yeah.
But again, he was willing to testify. And in 2003, really, the only thing that had changed was my client had been convicted.
Well, the statute of limitations may
Right.
have run as well.
But he came to court I think there was a hearing in February of '99, so he was there ready to testify then as well.
What was the source of the information that I recall from one of these, that he actually, Farrell, thought or was told by defense counsel or an investigator perhaps, that he couldn't be convicted for possession because it was only a photograph?
I don't think anyone told him that.
That he just believed that?
I think he believed it. I think he also just didn't think it was that big a deal, that there was, I don't think there was a lot of time. My recollection is there isn't a tremendous amount of time spent on his potential liability in the transcripts. I mean, my recollection of it is that people sort of accepted, did he have some? Yeah, but was it a lot? Not really, but it was something. And that he was willing to testify regardless of that.
So what is the legal standard you're asking us to impose? That, is it the intimidation standard, that it's okay for a police officer to speak with a defense witness as long as he does not intimidate him? Or are you saying that it's not appropriate for a police officer to speak to a defense witness, period?
You know, anybody can talk to anybody. And I think that, you know, enforcing a kind of rule like that would be next to impossible. I think that I sort of look at it much more narrowly and sort of case specific in this case. Should a government agent be having, you know, private conversations with defense witnesses where they're talking about potential liability? No, they shouldn't at all.
So are you saying that, I mean, I'm just trying to get a flavor as to, because I know the judge found that there was no intimidation. So are you telling us that we need to find that to be clearly erroneous for you to prevail? Or are you saying that something less than intimidation may suffice?
I think the trial court, I don't think that the standard that the judge applied was correct. And in my brief, I talk about this a little bit, that the judge's decision turned on, he made the decision not to testify after getting appointed and speaking with a lawyer. My argument is that the situation changed when the threat and intimidation occurred. That when that occurred, things were different. And if police officers, if government agents are going to just talk to government witnesses, hey, what are you going to say or whatever, that's one thing. But talking about their potential liability or anything else, they absolutely should not be doing that.
Okay, well, then we need to get,
Right, I understand.
I'm trying to sort of figure out, there's a difference between threats and intimidation versus a police officer saying, you know, Mr. Farrell, you've just admitted to possessing a gun. I don't know whether you have a license to carry, but if you don't, you may be subjecting yourself to liability for that, and you may want to think about consulting with an attorney before you say that.
Yeah.
If that had happened, would you be saying that too was too much because it essentially is the police telling him to speak to an attorney, knowing that may result in him not testifying?
You know, I think there's, obviously it's a murky situation, but I think that one of the cases talks about any time this comes up, and I can't remember, I think it might have been Turner, talks about when this situation comes up, there shouldn't be a self-help situation. The government agent shouldn't be taking care of this. This is a problem for the court. And if a defense witness needs to be talked to, then it should be the court that's talking to them. So I just looked.
Okay, but again, I'm just trying to.
Yeah,
so,
I understand.
So you're saying that we should reverse, because even if we accept Judge Quinlan's finding, or find it not to be clearly erroneous, that there were no threats and intimidation, the mere fact that he was, according to Judge Quinlan, saying you should confer with counsel would suffice for you to prevail?
I'm sorry, can you say that?
Let's assume we accept that Judge Quinlan's finding that there were not threats and intimidation was not clearly erroneous. I know you think we should not, okay, but let's assume we do.
Right.
Are you saying to us you still win because she did find that as a result of the conversation with the detective, he immediately sought to speak to counsel?
Correct.
So you're saying that that's enough for you to win?
Correct.
And so the standard is whenever a police officer tells somebody that he may need to confer with counsel, where that may likely result in the deprivation of defense testimony, that suffices.
If it's that serious, if it's going to result in a deprivation of defense testimony, it's going to prevent or inhibit the defense from presenting their case, go talk to the ADA, go talk to somebody else. It's not a self-help situation, especially not in a private room. Just moved on briefly. I see my time's coming down. Quickly about the gun. and then I want to talk about the reward for the last couple of minutes of the argument. Detective Vickers discussed the gun. There's no documentation for the decisions he made, why he decided it was a Rome RG. There's no background about his experience other than being a gun collector in the military. Defense expert looked at the picture, the blown up picture, and said that, it narrows it down to a couple 100,000 guns. It could be 8 right twists, it could be 6. You have absolutely no idea. So Vickers' testimony that all guns of this particular class have the same rifling is just not true. Is based on my understanding of the subject is just not true. And I think Leisinger's statements are much more accurate, that if all you can get is a class doesn't tell you anything about rifling.
Could you address the fact that the Commonwealth suggests that notwithstanding all of that, that your expert in connection with the motion for new trial reached the same conclusion as the Commonwealth's experts regarding the bullet fragments?
There are really two.
And the bullet fragments are the only forensic evidence you say in the case, right?
Right. There's really 2 parts to the gun conversation. One part is the fragments and whether it was 8 or 6. And the difficulty with that, or the problem, is that George Foley, the first person that looked at it for the BPD, just eyeballed it, didn't even put it under a microscope, and said 6. And then they've got this picture, and they decided, well, that looks like this kind of gun, so maybe we ought to look, that's an 8, if it is a Rome RG, that's 8 with a right twist, so let's look at these slugs again. And then they go back and look at the slugs, and they're like, wow, how about that? They are 8 right twist. Okay, stop there. That part, Leisinger says, the conclusion is correct. The process they followed, which is more important to my argument, is that they got there in this very screwed up, unprofessional, haphazard, subjective way. They really backed into it, almost sort of confirmation bias. Actually, it really was sort of confirmation bias. The result is correct. It is 8 right with a twist. But going forward, whether the identification of that particular gun as the gun, that's the part where Leisinger completely disagrees.
As the type of gun.
Correct.
Not the gun.
Right, type of gun. Because at that point, short-nosed black revolver. You've narrowed it down to several 100,000 guns. Leisinger says maybe even 1 million. It's on page 178 of the record. And just says that doesn't tell you anything about the rifling. Could be 8, could be 6. You don't know. And I will add, before I move to the reward real quickly, I want to add that, in case it got sort of buried in everything else, the photo was taken 5 months before the shooting. It wasn't the day before, or the week before, or anything like that. It was in November, and the shooting occurred in April. Real briefly, just talk about the reward. The victim in the case was a clerk at a Christie's. Christie's posted posters at that market that there was a $25,000 reward for the arrest and conviction, information leading to the arrest and conviction. Natasha Hamilton came forward. She testified at trial. That poster actually is on page 36 of the record. Defense counsel requested a specific instruction for her to red flag for the jury that said, look, this woman has an interest, an ongoing interest, an interest in the outcome of this case.
I take it she was cross-examined extensively on that point.
Correct.
It wouldn't be difficult for the jury to miss that point.
Well, Miranda adds other factors to that.
Miranda was decided, what, 12 years after this case was tried?
It's on direct appeal. He is entitled to every holding.
Oh.
Well, Luna was decided before.
And what was the law when
The
trial was?
Luna was decided in 1991 prior to trial.
And that says what?
That it's strongly suggested that under these circumstances, if requested, that an instruction is given.
And that had to do with a private offered reward or a government-sponsored reward?
I'm not recalling right now. And in the affidavit, I'll add just as my time is winding down, on page 186 of paragraph 23, filed with this new second new trial motion, is an affidavit of the defendant's mother that says very clearly that she collected that reward. That after trial, after my client was convicted, she went out and she collected the $25,000, which for a woman who was periodically homeless and having her children taken away, you figure $8 an hour works out to about a year and a half at 40 hours a week in one fell swoop. My client's entitled to a new trial.
Thank you,
Say it.
Counsel. Yes, ma'am. Good
Good
morning.
morning, Your Honors. May it please the Court, Assistant District Attorney Amanda Teo for the Commonwealth. I'm asking this Court to affirm the defendant's convictions, including that for the first-degree murder of Geta Yalu. Your Honors, if I may, I would begin with the two claims that deal with the witness Randy Farrell and Detective Keeler. And I would begin with the end of that analysis, because for the defendant to succeed on either of these claims, the newly available evidence claim or the quote-unquote threats claim, he would have to show that Farrell's testimony would have had a material and favorable effect on his case. And he has not made that showing. The reason he cannot make that showing is because even if Fenderson was the owner of the revolver, that would not controvert the Commonwealth's theory that the defendant had access to that revolver or to another like it. In fact, Farrell could not testify that he saw Fenderson leave the defendant's apartment that day with the guns. Farrell, like Emerson Ocampo, who did in fact testify at trial, arrived at the apartment after Fenderson did and left the apartment before Fenderson did. So he has no idea whether or not the revolver left with Fenderson or remained behind in the defendant's apartment.
So what was the argument of the prosecutor at trial as to the significance of the photo?
The significance of the photo was in two respects. One, to show that the defendant, in fact, had access to firearms inside his apartment or had firearms inside his apartment, but also to substantiate Natasha Hamilton's testimony that she had seen a black revolver in the defendant's bedroom at some point prior to the crime. Moreover, I would say that not only is this testimony not material and indeed could be cumulative, it would actually not be favorable to the defendant because Farrell, unlike Ocampo, testified that he had seen guns in the defendant's bedroom on a number of different occasions. Ocampo had said that he'd only seen guns on that one occasion. He's best friends with the defendant, and he had never seen other guns in the defendant's room. And Farrell would have testified that there were numerous other guns there. And so that actually would have supported the Commonwealth's proposition that the defendant had access to other .38 caliber revolvers. Finally, I would like to move on to, well, first of all, I would conclude, therefore, that there's no material or favorable testimony that Farrell would have given had he been available to the defendant at trial. Now, the reason why Farrell was unavailable to the defendant was not because of any threat or intimidation on the part of Detective Keeler. It was because he consulted with his own court-appointed experienced counsel and chose to invoke a proper Fifth Amendment privilege. That's the but-for cause of why Farrell was not available to testify at trial. The motion judge found twice over, in fact, that there was no evidence of any intimidation or threat, and that it was only after conferencing with his own attorney that Farrell decided to invoke the privilege.
Well, let's turn this around, okay? Let's imagine that the prosecution has its witnesses outside, and the defense investigator is out in the hallway speaking to each of the prosecution witnesses and saying to them, you know, if you testify as you plan to testify, you're going to be incriminating yourself. You may really want to confer with counsel before you testify as you plan to testify on behalf of the prosecution. Any complaints? Is that fair game for defense investigators to do?
I would say that that is not the best practice, and as I would acknowledge here, the Detective Keeler did not do the best thing by conferring with the witness in a private room and getting into the substance of the witness's testimony. However, the content of that communication, as in your hypothetical, Justice Gantz, would be appropriate, because in that case, if those witnesses were, like Randy Farrell, unaware that they had exposure for what they were about to testify to, unaware that they had any such thing as a Fifth Amendment privilege not to testify, then the assistant district attorney as an officer of the court and the judge should have advised those witnesses that they had a Fifth Amendment privilege to not
So
testify.
you're saying two
Or
things. You're
get
saying
the-
it's perfectly appropriate but ill-advised. How can it be both perfectly appropriate and ill-advised?
I would say that the better practice is for the investigator or Keeler in this instance to approach the court and ask for the court to instruct the witness that he should confer with his own counsel. However, the end result of that was that the witness got the proper advice, which he was unaware of prior to showing up to testify on behalf of the defendant. So I'm saying even though that might not have been the best practice, it is certainly not amount to a threat and is not government misconduct within the meaning of Penta, Turner, Smith, et cetera.
Okay, and what would he have had to do to rise to the level of government misconduct, which would require sanction?
Sure, it would be something akin to what happened, for example, in Turner, where the assistant district attorney who was prosecuting the case went to witnesses at a bar, potential defense witnesses at a bar, and told them, you better not testify. If you do, I'm going to charge you. Those witnesses decided not to testify, not because they conferred with their independent counsel, but because they were intimidated and threatened by that prosecutor who had the ability to bring the charges in that case. Here, that's simply not what happened.
Well, but that's what Farrell says happened. Farrell says he was strongly suggesting that he's going to be in trouble with regard to the murder that he's testifying about in the Keeler case.
Justice Gibbs, I don't believe that that's what Farrell testified to, and of course this court can look at his testimony from the evidentiary hearing. Farrell testified, and this is the testimony that Judge Quinlan credited. He said that Keeler asked him if he had a lawyer, that he had his own cases to worry about. He might want to think about his possible exposure in these cases. And while it's true that Farrell said, I felt threatened by that message itself does not rise to the level of a threat or government misconduct.
Well, he wasn't saying you better worry about your exposure for having a gun in this case. He was saying about other cases in which Keeler was involved, right? So, I mean, you could see how somebody could reasonably understand that as being threatening.
Your Honor, I think he was actually, Farrell's interpretation was actually both, that he was saying he could be exposed to a gun possession charge in this case on the basis of his testimony and the photo, and also in that other murder case that Detective Keeler was involved in. But again, I don't think that rises to the level of a threat because, again, the but-for cause, what happened after that conversation was that Farrell went to defense counsel and asked for a lawyer. Now, this court can look back at the transcript of trial and see that when defense counsel approached the court, and this is in volume 7 of the transcript, and asked the court to appoint counsel for Farrell, defense counsel never said anything about threats or intimidation. Defense counsel said, there are some detectives out there that are talking to my witness. They said you might get in trouble. I would like this witness to have the advice of court-appointed counsel. And later on in that same volume of transcript, when John Courtney, who was the witness's appointed counsel, came up and did the voir dire with Judge Quinlan, he said, quote, and this is on page 99 of the transcript, I've discussed the matter with Farrell, and he, as a result of that conversation, informs me he will exercise his Fifth Amendment privilege with respect to all questions. So Justice Quinlan's ruling in both her first and second motions for new trial, that it was only after the defendant sought advice of his own counsel that he chose to invoke a very proper fifth. Those findings are amply supported by the record. There was no abuse of discretion or clear error there.
If I could turn you to the issue with regard to the rewards and the instruction.
Sure.
Did the defense request an instruction with respect to the reward? I'm looking at the cooperating witness instruction, which is referenced in your brief, but I don't see any mention of awards.
Right, Your Honor, that is the only instruction that I found that even closely approximates a request for some sort of special instruction on the evaluation of credibility of witnesses. And certainly with respect to that request, Justice Quinlan's denial of that and her choosing to issue a general instruction on credibility, on the evaluation of credibility, was within her discretion. She did not need to use the precise instruction requested by the defendant. The defendant did not seem to request any other instruction. And also, just as a matter of fact, I would say to this court, there's actually no credible evidence that Natasha Hamilton actually collected the reward.
I'm sorry, I missed that. What did you say?
There was no credible evidence that Natasha Hamilton actually collected the reward from Christie.
You're saying she didn't?
I have no idea whether she did or not. There's certainly nothing in the record.
But if she did, it would be after the trial anyway.
That's correct, Your Honor. I'm just saying in terms of assessing any potential prejudice here.
Well, under our current case law, focusing right on Miranda, noting the fact that this reward was out there for someone who provided information leading to the arrest and conviction of the defendant,
Right.
would a special jury instruction be required?
I think it might have been required if there were any showing at trial that she actually brokered some deal with Christie's to get that reward, or asked for that reward.
How could she do that if her conviction was a prerequisite for collecting the reward?
Well, certainly there was nothing in the evidence presented at trial.
It's almost impossible to do.
I understand, Your Honor. I understand. But here I'm just saying
It
there
has
was
to be done post-trial, doesn't it?
well, certainly it's the defendant's burden on a motion for new trial to show that there was some sort of substantial likelihood of a miscarriage of justice here, and where he cannot show that Natasha Hamilton even collected the reward. Where's the likelihood of a substantial miscarriage of justice?
Well, let's suppose that there was credible evidence.
That she did in fact collect the reward.
Christie says we gave it. We paid it to her.
Well, then I would go back to what Justice Cordy was questioning my colleague about earlier, which is that Miranda was not in place at the time of trial. There was certainly, based on the case law at the time that Justice Quinlan, well, first of all, Justice Quinlan was never asked to give any instruction of this type. If she were asked, she comported with the case law at the time of trial. And that's the end of it. In terms of just assessing whether or not there was any prejudice here, everything with regard to the reward was before the jury. Defense counsel cross-examined Natasha Hamilton extensively about the Christie's reward, and the jury rejected that evidence or decided that she was credible anyway.
Well, my question is a little different than that. Under our current jurisprudence with respect to rewards and how they should be dealt with, would a special instruction be required in light of our decision in Miranda in these circumstances where there was a reward available for someone who gave information leading to the conviction of?
Your Honor, I can only say there may or may not be, because there's again, she was not asked to provide that instruction. There was not enough evidence to require that instruction.
Well, what evidence would be necessary to require that instruction?
Well, at the very least, that the jury had to have heard that the $25,000 reward was contingent on the successful
They didn't hear that?
conviction. I think they heard that there was a $25,000 reward. I could be wrong, Your Honor, and I don't want to misrepresent it to the court.
Having the record, the Crime Stoppers thing, was that part of was that evidence
I'm not sure, Your Honor.
on page 36 of your record?
I would check on that, and I could get back to this court by means of a 16L letter. I don't want to misrepresent what the record has or does not have.
That said information leading to the arrest and conviction of the person who shot and killed Geta Yelu.
That's right, Your Honor. But let me go back again to the idea that Justice Quinlan was never asked to give this instruction. And so the idea that she should sua sponte issue an instruction that this court had not cognized at the time of trial, that could not possibly rise to a level of a miscarriage, a substantial likelihood of miscarriage.
So the instruction she was asked to give is the instruction, is on page 43 of your brief. I think that's what I'm looking at.
That is correct, Your Honor.
The cooperating witness instruction?
That's right.
And I take it there was no deal struck with her for her testimony?
There was not, Your Honor. There was no quid pro quo between the Commonwealth and Natasha Hamilton.
She was not promised that she would not be prosecuted for any crimes in connection with this, anything of that
Exactly
sort.
right. There was no prospective reward. The Commonwealth did, in fact, for her own protection, put her up in a Holiday Inn for a couple of weeks and helped her secure Section 8 housing and paid for her first and last month's rent. All of that information was presented to the defense before trial in the form of discovery.
Those are all
That-
benefits given to her pre-trial in connection with.
Exactly, Your Honor. And the defendant did, in fact, cross-examine Natasha Hamilton extensively based on those.
So you're saying that a instruction that says you should examine testimony with caution applies only when a person has received a benefit in the form of some previous crime being treated more leniently or not prosecuted?
I would say that based on this court's jurisprudence, there at least has to be some sort of quid pro quo. Everything that Natasha Hamilton received from the Commonwealth was done prior to her testimony, was not contingent on the testimony she was going to give. This was not like a Champa situation. And so there was no quid pro quo or any kind of contract here for the defendant's testimony.
Well, what about Luna? Is this a Luna situation? That was good law back in the 1990s.
No. Again, there was no request for a Luna instruction here. So I think we do have to hold the defendant to what happened at trial and to the burden that he's required under the Rule 30. There is no substantial likelihood of a miscarriage of justice here. Your Honors, in conclusion, I would ask that you not utilize your powers under 33E to reduce or nullify the verdict. The defendant was fairly convicted by a jury. He had the benefit of 2 motions for new trial and multiple bites at the apple on some of the claims that he raises here today. This case began over 15 years ago, and I would ask this court to bring finality to those convictions by affirming the defendant's convictions.
Thank you, counsel.
Thank you very much.